college, they're getting um, 18. And when they do, it's really important to learn about the legal challenges that could arise now that you've got an adult. So everybody's probably familiar when you've got a kiddo that's under the age of 18, they're considered a child. They don't get to make legal decisions. But the moment they turn 18, even if they're still in high school, they get to make their own decisions. So what we're really going to talk about tonight is the most important documents that you need to have when you have an 18-year-old, whether they're going off to college, whether they're staying at home and are going to work through a couple of years before they decide what they want to do in their future. So the most important, again, is just to remember that at 18, they become an adult in the eyes of the law. So they're no longer a juvenile, and that applies to any kind of privacy laws that we may have. So HIPAA is one of the most important. That's something that is a federal law that is for protected health information. When your kiddo turns 18, you don't have a right to go and access their medical records unless they've given you permission and consent. So that's one of the first documents on our list for young adults is a HIPAA release. This is your 18-year-old saying, hey, mom and dad can have access to my medical records. It's super important that they have access to, or you have access to your kids' medical records so that you can make informed decisions about their care. When we have kiddos going off to college, they may kind of feel like, oh, I don't want to share this with mom and dad or whatever, because I'm embarrassed. Well, it's really important that you have access so you know what medications they're taking. They could go to, the student union building and see a doctor. We want to ensure that you have access to that. So a HIPAA release is just a document that's going to allow you to access that medical record. Accompanied with the HIPAA release is a medical power of attorney. So, this is a document that allows parents or any designated individual really to make medical decisions when you cannot. So, let's say that your kiddo is involved in a car crash or an intramural game and they ran into somebody on the baseball field. That child might need, or not child, that young adult may need someone to make a medical decision for them. And in the event we don't have lines of succession and people who are going to be designated to make those decisions, it could come down to a fight about whose decision is going to rule. Is it mom's? Is it dad's? Especially for blended families, this is something that is really important because a child, I keep saying a child, you guys probably are always going to think of them as children. So that's where my mindset is at. These young adults, are going to need to have somebody designated to make a decision for them. Um, it could arise in many different scenarios. Like I said, something as serious as a car crash or something as silly as an intramural mishap. So this one again just designates individuals to make medical decisions for you when you're not able to. The last document that I think is important, and I will touch on a couple others that are just extras, is the financial power of attorney. So the financial power of attorney is a document that allows an individual, usually a parent again, to make financial decisions for you when you're not able to. So if something happens and bills need to be paid or money needs to be moved and transferred, this is when an individual can allow and authorize someone else to do that for them. Most importantly, with our kiddos, where we see that come into play is signing a lease on your child's behalf or managing their bank account or even dealing with the IRS. I know for me personally, there's sometimes where I'm like, I don't know what this is. I'd love for my mom to step in and help and facilitate. The IRS, for example, is not going to talk to someone unless they have the proper authorization. So that's where the power of attorney that deals with financial decisions really comes into play. So we've got three documents in what I think is our college estate planning package that's so important for our 18 plus year olds to get. There is an extra called a directive to physicians, which is a document that says, if I'm suffering from a terminal or an irreversible condition, do I want to remain on life-sustaining treatment? Why we don't really include that in our package is because oftentimes our 18-year-olds aren't there thinking about that decision, and what do I want to have happen in that specific event? It just kind of depends on your kiddos maturity level and whether or not they are able to make a decision like that. What we oftentimes recommend in that case is talk with your medical power of attorney, make sure that they know what you'd like to do. And if your kiddo feels comfortable executing that document, we can certainly do that for them as well. So again, just to kind of recap, if you don't have these things in place, it could limit your access and availability to obtain access to protected health insurance information, make quick decisions like medical decisions or financial decisions. It could delay that care when we're going through, some sort of experience. So it's just really important to be proactive. And I would also encourage all of you guys, if you don't have these things in place, to ensure that there is a plan written so that you are able to, have somebody act for you when you're not able to, whether because, you are suffering from some sort of medical condition or you're incapacitated. We just want to make sure that everyone is protected at all points in time. I feel like that was kind of like a short and sweet version of a typical estate planning consult. Does anybody have any questions? And hopefully you guys all were able to hear me. I know I saw some things coming through that maybe we couldn't, so I apologize.
Hey, Bree, quick question.
Yeah.
So you said there's 3 documents. So what I jotted down, so the HIPAA release includes the medical power of attorney. Then you talked about the financial power of attorney.
So
I guess to be just clarify, what are those 3 documents then?
absolutely. So first is the financial power of attorney, second is the medical power of attorney, and third is the HIPAA release. So 3 documents. Your medical power of attorney and your HIPAA release, though, go hand in hand. We want the same people to be designated on those same documents. If you have a medical power of attorney that can't access your medical records, they're not going to be able to do a very good job. We want to make sure we give them the most power possible.
What does the HIPAA stand for?
It is Health Insurance Availability and Affordability Act. I always mess this up. Let me Google it.
No problem. I was just, trying to remember HIPAA myself. So yeah,
Health Insurance Portability and Accountability Act.
There it is. Okay. Hey, thank you.
Of course. And so I probably should have said this at the beginning. I am an estate planning attorney with the Hunt Law Firm. We are out in Katy, actually in the same kind of complex as Info for College. And so we have a college estate planning package for those 3 documents for a flat fee of $350. So the way that it works is to execute these documents, your kiddo has to be 18. But we basically set up a real quick 15-minute consultation. I run through what the documents are so that they're aware. You guys, of course, are welcome to sit on the consultation as well. We walk through who they would want to be in charge of each of those documents. And then when we're good to go, I'll send you guys a worksheet, a legal services agreement, that's just our contract, and then a link to pay the flat fee. And with these college estate planning packages, I mean, I can get them done in and out within a week's time. So there's not a lot of, sitting around waiting. Our internal practice is 3 business days from the date you retain to get drafts. But with these, they're so quick, they're so easy. And what I have seen is the longer we let them linger, the longer it takes for somebody to come and execute. So if I can get them turned around quickly to you guys, y'all can get in and execute, especially before graduation and parties and summer and all that stuff starts.
What do you recommend for duration?
Can you say that again?
Oh, I was just to follow up on duration of these documents, how long they'll be active. What do you recommend for the duration period?
They will be active until they are revoked. So until that child makes a new directive, they're going to be in place.
Thank you.
That is correct. From about the FERPA waiver, that is something that we don't do. I'm not sure if you guys have access to that through Info for College, but it is something that I would certainly recommend. And yes, I can provide my information. I'll put my email in the chat. So if anybody wants to set up just a quick consultation, you're welcome to just email me and we can certainly take care of that. I am, just disclaimer, going on vacation Thursday and Friday, but I will return all emails when I return.
Can you please repeat the cost for
Yes.
getting the 3 documents?
It's $350 flat fee. So that means you only pay one time. That takes care of the consultation, the drafting, any review time. So if there's questions, as well as the signing ceremony. So once we provide drafts and they're approved, you guys will come to the office, or it just can be your 18-year-old, come to the office. We'll provide 2 witnesses and a notary, sign the documents. We will give you the originals, or we'll give your kiddo the originals, and also give a USB or a thumb drive so that you can make copies. And we recommend that the parents keep the originals, especially when they go to college, because they're probably going to be moving quite a bit. But they can always email a copy to themselves. But you guys are going to be the ones, I would imagine, who are going to be in charge. So you would need to present them when the time comes.
Understood. Thank you.
Of course. So I put my email in the chat. It's my first and last name, and then at huntlawtexas.com. So if anyone's interested, I'm happy to get you set up for a consultation. On our social media sites, I want to say it's I think it's mid-May. We'll be rolling out some promos. I'll make sure to pass that on to you, Yesville, so that we've got them. And you'll see all of that there. Okay, there's another one. Yes, I will write them down here. Power of attorney, medical power of attorney.
Are these documents valid in other states?
They're just going to be valid here in Texas. So if you have a kiddo who's going out of state, you just want to make sure that, well, I should back up. The HIPAA release is going to be good for everyone because it's a federal law. But the medical power of attorney and financial power of attorney, the other states may govern, but we all know that college kids do not move to college with the intent of staying there. And so that's the argument that we as estate planning attorneys raise is, well, that kid is not domiciled there in that specific state. They're really here. We too in Texas recognize and accept documents from other jurisdictions if they're in compliance with our laws. So again, it doesn't hurt to have these, even if your kiddo's going to school in Florida or California. Those specific states would, of course, have the ultimate decision-making sway. But something written down is better than nothing.
Thanks.
That is a good question. What if they study abroad? So I studied abroad myself when I was in college, and I can tell you, I don't think my parents had anything. But what we did do is there was some sort of like I don't even want to call it a policy. I went to Baylor for undergrad. There was some sort of protection that I was able to get through the school that allowed me to be covered. My parents also had access at that point in my life. I was not paying for anything to all my finances and things of that nature. But the healthcare decisions is one of the most important. And so I want to say when I went, we had to sign some sort of something. I was in Europe that authorized our professors to act on our behalf in the event that something happened and we needed medical care. That's a good question, though.
So we have to wait that the students turn 18, right? We cannot do it before.
Correct. So they have to be 18. So the second they turn 18, I mean, we can always have the consultation before, but they can't sign our legal services agreement until they're 18 or sign the documents until they're 18. And no, the documents do not expire. So they are valid for ever until perpetuity until they're revoked.
I have a question. What happens if a student ends up in the hospital and the parents don't have any legal document in place?
That's a great question. So here in Texas, we have a set of authority that basically details the order of priority of who's going to get to make medical decisions. Obviously, the parents are first. However, it does not specify, is it mom or is it dad? And so why this document is so important is so that, you have that established order of priority. Because when we have two parents who disagree, they're where do we go from there? They basically are going to continuously be in a fight over what should happen and what standard of care should we give this child. So there is ways, I guess you could say, to ensure that a parent is able to take care of a child. But what we ultimately want is someone to be the authoritative deciding factor. Oftentimes, what we advise highly against is appointing co-executors, meaning two people who are able to make decisions together. Because what happens if people can't make decisions together? If you have two people with opposing viewpoints and we're fighting over what should happen, the only way that the court and the legal side of things can resolve is to go to court. And that's what people don't want to do, is to go to court and fight over who should make the ultimate decision for this child. It can obviously result in lots of turmoil, horrible then, relations with family members, parents that just are no good. I see another question. What if our son's going to university in another country? Would these documents apply? I would recommend that if they're going to university in another country, getting documents based in that specific country. At that point in time, you are not at the mercy of Texas, and Texas is not going to be able to tell Mexico or Brazil or,
So these,
No,
Great.
but we need it every time when he comes here. Anyway, when he comes to visit, something happens. You always
Absolutely.
stop
So
it.
having
For the
having
people to study
documents,
abroad.
yeah, that's a good idea. So having documents here in place so that if something happens in the United States, he's covered is good. And then ensuring, hey, I've got whatever is needed in Europe, in Mexico, to ensure that he's covered there, I think would be making sure all of your bases are covered.
Regarding the academic records, so can a student give access to the academic records or grades to their parents?
Yes, that is it the
FERPA?
FERPA form?
Mhm.
Like I said, we don't do that, but that's my understanding of what it is. It's school
Mhm.
records. So they're private unless that child gives authorization for that parent to have access. And again, it's one of those things that these kiddos might be thinking, "Oh, I don't want my mom and dad to know that I got a B+ in, calculus." Yes, that may be true, but if your parent needs to help and assist you with anything, we want to make sure that they have the ability to do so.
Mhm. So they have to give authorization to the parents to see the grades, right? So okay, the authorization of FERPA. Are there any documents or specific, I don't know, something specific for students with disabilities? Any document?
That's a good one. So, what disabilities are you referencing?
I mean, like, let's say dyslexia. I mean, is there anything that extra that the parents should do?
That's a good question. To my knowledge, the answer is no. However, one of the most important things is ensuring that in the event your children need some sort of government assistance, that you're going to have the ability and the authority to help seek that out and assist with it. And I'm not talking about accommodations in school or anything like that, but more so, my child needs monetary assistance because of their disability. So
Mhm.
that's when that financial power of attorney kicks in and allows you the ability to assist in setting those things up for someone. Um, there may be some sort of document, I would imagine governed by the federal government of, now that I have this child who is receiving accommodations in school, this parent can talk on that child's behalf. But I think that that's all gonna fall within that FERPA stuff.
Mm.
So I don't, I guess the answer is I don't really know the answer. However, I do know that if a child is intellectually disabled and lacks capacity to make
Mm.
decisions for
Mm.
themselves,
Okay.
they are not able to actually enter into the documents I'm
Mhm.
presenting today. So if you have a kiddo, which I think all of us, all of you on the Zoom, more than likely are not in that scenario, you know, just keep that in mind, that if you do not have capacity to make decisions for yourself, you cannot sign and execute these documents.
Thanks.
One quick question. In case the kid decides to revoke those documents, are the parents notified?
No, you are not. You are not.
Okay.
And then I see another one. Are there any other related to this topics, kiddos becoming adults, going to college? These three I would say are really the core. Most children at this point in time do not have estates, as we would call them. So having a will is not necessarily important. I don't think, this is bad to say, I don't think I got a will until I was like 28, and I had been a lawyer for quite a while. But most kiddos are not there yet. You could always do some sort of will, last will and testament, a disposition of remains, what happens to my body when I pass away, a declaration of guardian, which is who should be my guardian in the event that I'm incapacitated. But for our young adults, making sure that medical decisions and financial decisions are taken care of, to me, is the most important.
I have a question. I mean, I'm probably confused. I remember that I did for my son a living will. So which one will be now? I'm like, I mean.
Yeah, no, you're good.
Okay.
So a living will is not a document that we put in our estate planning our college estate planning package. It's that extra that I talked about called a directive to physicians or a living will. And it's the document that says if I have a terminal or an irreversible condition, do I want to remain on life-sustaining treatment or do I have any additional request? Like I said, most of our fresh 18-year-olds are not thinking, what do I want to have happen in that scenario? And some are not ready to make that decision yet. So we don't want to force that upon anyone to make that decision. But it's something that we can always throw in the event that somebody wanted it. So I typically present about it, and most of my kiddos are like, "Oh, no, 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 I don't want to think about that. I'll let my mom and dad make the decision if the time comes."
Okay, thank you.
Of course. Yeah, that's a really good question. So I always recommend for your physicians that they have a copy of the medical power of attorney and the HIPAA release so that they've got access to it. As far as the power of attorney goes, there's no one that you really need to present it to until the time comes to act. And I apologize for my dog making noise.
I know it's probably, I mean, it's not part of this, but there was a question, if you could tell us the difference between a will and a testament.
Yeah, that's a good question. So those words are, oh, give me
That's-
one second. Let me put them outside.
That's fine, that's fine.
He just wanted to be seen. So we refer to a will as a last will and testament. It's just an interchangeable word. What you might be thinking of is a trust. So a will is a document that basically says, when I pass away, here's what's going to happen to my stuff. Here's who's going to be in charge. If I have minor children, um, where are they going to go? A trust is a living document, or not a living document, but kind of like a living entity that all of the assets that you have are put into it. And so when you pass away, the trust takes over so that you don't have to go to probate court. That's what most people want to avoid, is going to court, having a hearing about the will and whether or not it's valid. It's not meant to be a crazy or scary process. It's really designed to be simple. But sometimes people say, I don't even want to chance it. I want to have a trust so that my estate doesn't have to go through probate. But it's important to know that if for some reason you didn't fund your trust correctly, the only way then that somebody could have access to certain assets is by going to probate, and going through the probate process. So what we do when and this is just kind of an aside for the parents, what we do when we are doing our estate planning and determining, what is the best vehicle for my estate, is the number one goal: how can we avoid probate? How can we avoid having to go to the court? So we talk about the different assets that you have and whether or not they're payable on death, whether there's a way that we can avoid probate, maybe without creating a trust, so that you don't have to always remember, oh, my bank account, it's not in my name anymore. It's in the name of the trust. Oh, this vehicle I just got, it's not in my name. It's in the name of the trust. So we talk through all the different scenarios of the different property that you have and how we can best accomplish your goals, through that process.
Thank you.
Yeah.
Any other question?
Yeah, but maybe I'm not sure if it's a dumb question, but the normal period of let's say expiration of these documents is until our children get married, and then they
No.
change their medical power of attorney in all of these documents?
That's a really good question. It's not a dumb question at all. So until your children execute a new power of attorney or a new medical power of attorney, you are going to continue to be in charge. So when they get married, the burden falls on them to execute a new one and name their spouse as the decision maker.
Okay, thank you.
Yeah.
Okay, well, if there are no more questions, so thank you so much for sharing your time and expertise. And so we will contact you. So we have your email. Thanks for, well, we are learning on this topic and it's very important, actually. Thank you very much.
Of course. Thank you so much for having me. And if anybody has any other questions, you guys are certainly welcome to email me. And like I said, if you're ready for your kiddo to get this, just let us know and I'm happy to help you guys.
Thank you.
Thank you. Bye.